1. The different descriptions of clothing worn by the deceased on the day in question. 2. There is no evidence presented that blood was found on the school clothes worn by Drayden on that day. 3. No murder weapon was recovered. 4. The applicant maintains that the exhibits recovered were not present in the flat on 14 May when hordes of people had access to the flat. Neither was any of these exhibits pointed out to her. 5. The exhibits seized 2 days later on 16 May were not present in the flat. 6. Third parties had keys to Unit 13. Even unknown parties had access to the flat. Anyone, therefore, could have placed those exhibits in the flat. 7. No eyewitness can confirm that Drayden was in the company of applicant after being dropped off, or that she was the last person being seen with him alive. 8. Sniffer dogs present at Swazi Place proceeded to another unit on suspicion, but that the police did nothing. It is possible that the pillow was recovered from that unit where the sniffer dog picked up the scent of bodily fluids, referring to sperm, which was said in passing to the applicant. 9. Applicant, upon her arrest, was informed that the time of death was between 4 and 5 a.m. Applicant produced evidence that she arrived at Unit 13 at 15:22. 10. Various tenants use the same staircase and no one observed a body. The assumption can therefore be drawn that someone placed the body there after the applicant has already left. The defense goes on to argue in conclusion that someone has gone to great lengths to implicate the applicant in this case and defeat the ends of justice. The defense submits that the public outcry in this case, which existed at its inception, no longer exists. The defense states that the applicant can still be in custody for a lengthy period of time pending the finalization of this trial, and therefore, in conclusion, argued that the absence of the applicant having attempted to flee this court leaves this court with no option but to conclude that applicant is a suitable candidate to be released on bail. The state, in its closing arguments, sets up a factual matrix which, prima facie, as argued, points to the applicant as the prima facie cause of Drayden's death. The state argues that the applicant has done so by going onto an elaborate scheme to evade justice. As follows. 1. Applicant reported Drayden missing while knowing that the child was inside Unit 13, harmed. 2. Applicant pointed the transport driver as the last person to be with the child, causing him apologies, we had an interruption with the electricity. Kindly reboot and let me know when we're ready to proceed. Court adjourns for a few minutes.